Want to know how to set up your patent application for a greater chance of getting issued as a patent with a greater chance of licensing and litigation success, which can translate into much more money? Hi, I'm April Mosby, patent attorney with over 25 years of patent prosecution, licensing, and appellate experience. And in this video, I'm going to be going over the 7 steps, which are in essence the solutions to the 7 common mistakes that inventors make. These steps can set your case up for success and more profit. So, what's the first mistake? The first mistake is a failure to perform a broad patent search to see what is the actual state of the art and technology that's presently exists around your innovative concept. Well, fortunately, there is a 7-step process of analyzing what the prior art is and where to search the United States Patent Database for patents and applications, as well as the international database for patents and applications filed in the foreign countries. The secret of avoiding this is to just follow that process that is given on the United States Patent and Trademark Office website, uspto.gov. They will help you and guide you through a patent search. And by doing that, you can save thousands of dollars avoiding the fees associated with filing your patent, because if you have something that is already known, it's already been patented, it's already been applied for, you probably don't need to file a patent application. But also you can use that, and that will, I'll show you in one of the other mistakes that will help you to avoid one of the other mistakes. But let me move forward to the next slide. I don't want to get ahead of myself. The second mistake is a failure to present novel and non-obvious aspects to your innovative concept. During examination of your case, the examiner will look to see if the concept disclosed in your specification and in your claims is actually novel, is actually non-obvious. Novel, what does that mean? Is it new? Is it something that nobody else has seen before, thought of before? Is it in any other publication? Is it in a patent? Is it in an application? Foreign or domestic? Is it obvious or non-obvious? Obvious would mean if the examiner found reference A, patent reference B, and patent reference C, and the examiner says, well, if I put reference A, B, and C together, I will come up with your innovative concept, and they will say, well, that's obvious. It's you've got to make sure that there aren't portions of your innovative concept that are found in other patents. And so from the previous solution to the first mistake, from your prior art search, you can creatively look for your innovative concept, and then look to see what other people have done, and then design around what's already there. So you have to, think again, go back to the drawing board, think about what you can change, what you can add to your design that would take you over and above, that would distinguish your concept, innovative concept, from all others. That's novelty. That's non-obviousness. And so that will save you thousands of dollars avoiding the fees associated with prosecuting your case, filing and refiling your patent. So that is the second mistake. Onward. Third mistake. Failure to assess and accurately describe the innovative concept. Some people try to keep their innovative concept secret at the same time while they're filing their patent. You should not do that. You must fully disclose your innovative concept and thoroughly describe it in the specification. There must be clarity around your innovative concept. This is a must. And so how do you do that? How do you avoid this mistake? Well, you can look from all of your due diligence with your prior art search. You can look to see how they describe certain details. There's some things that are going to be standard. And so you don't have to reinvent the wheel with those details, but thoroughly go through those, use some of that information, use what you've discovered that is novel, that distinguishes your innovative concept above and beyond everyone else's patent or application, and thoroughly describe those things. Add all of those details, and you will save thousands of dollars avoiding the fees associated with refiling your patent, because you can't add to your patent application after you filed it. That's the reason why it's called non-provisional. Non-provisional means it cannot change. Provisional means changeable. Non-provisional, not changeable. So once it's filed, it is what it is. And if you need to add to it, you got to file another application, which is called a continuation in part, where you add more innovation improvement to what you previously filed. So that's more time and more fees. And so this is how you avoid this particular mistake. Okay, onward to the next one. Okay, so the fourth mistake is a failure to draft claims that will cover the broadest aspect of your invention. Okay, right here I have a picture of land and houses, a neighborhood, and a deed. I don't know if you've ever looked at a deed or read the deed, but a deed basically defines the outer periphery of the property that you own. So it will define it in terms of words. So it might say northwest 50 feet or 50 meters northwest on Clark Street, 30 feet on White Main Street. And it will define it in terms of words. So that is basically, it's an analogy to what the claim section does for your innovative concept. Your claims define the metes and bounds of your innovative concept, your innovative design. So you need to assess the state of the prior art. You can look to other claims, like during your prior art search again. If you look at some of those patents and you look at the way they're drafted now, because you're not skilled in patent law or patent claim drafting, you might want to take an extensive course for patent claim drafting, and you can. There are courses available to patent agents, or you can hire a patent attorney. And I would recommend that you go with someone with experience, at least 7 to 10 years of patent prosecution experience. They could thoroughly draft your claims to cover the broadest aspect of your invention. And the reason why I'm saying broadest aspect, like say if you drafted claims that only covered the front yard, it doesn't cover the property all the way to the backyard. So like when they draft up the terms for the outer periphery of this property, they include all of it. They don't just include the front yard. So, and that would be, of course, I'm using an analogy, and for each case or for each concept, it will be different. So if you do this right, when this is done right, this is where the gold is. Your claims are what produce the gold. This is what is used during licensing. This is what is used during litigation in order to defend your products and your services. That is, your claims defend you in litigation. In licensing, these are the claims that you can assert against other companies with their products that are reading on your claim. So you could save tens of thousands, actually gain tens of thousands of dollars of income from licensing and protect yourself from losses due to patent litigation, patent infringement issues. So that's how you resolve this fourth mistake. Okay, the fifth mistake is a failure to consider litigation consequences. Now, one of the litigation consequences. All right, so let's look at litigation consequences. We have precedential legal opinions. Basically, those are decisions that a court has rendered, a holding, and it goes through a thorough analysis of the rules and the laws relating to patent law, as well as specific tests that they generate that must be complied by. All right, so sometimes if you put certain words in your specification, and this is just going to patent profanity, we call it patent profanity. It's kind of like an inside joke for attorneys. But like if you were to put the word invention in your specification, it would duly limit your patent. Okay, so if you were to put problem or solution in the background, that's going to hinder you when you try to file your case in Europe, in the European Paris Convention countries. If you so there are certain words, and if you see those words, or certain things that you shouldn't do, like for the summary section, you should never have your summary too narrow. Your summary section should be very broad. Even your title should be broad. You don't want your title to be narrowed to the point where, like, say if you wanted to license your patent, and it's a widget that, and this goes into the sixth mistake, it's a widget that can be inserted in an engine, and say you're using it for a motorcycle. You don't want to have the title to be to motorcycle engines or whatever the widget name is with, and you include the word motorcycles, engines, whatever. You want to keep it very broad, like specifically to that particular component, because that component, and then narrow the claims. But anyway, I'm getting into the weeds of things. Let me go pull back up. There are a lot of different things that you need to consider. Just know, a lot of different things that you need to consider when you're drafting your claim. But this one thing that you can use, this is one big mistake, is to eliminate the patent profanity from your case. You can save tens of thousands of dollars of loss protecting your assets and your patent technology, your products and services. Okay, the sixth mistake is a failure to consider licensing ramifications. There are licensing opportunities. That's what I was trying to get into in the previous slide. There are licensing opportunities that you need to consider when you're drafting your claims and your specifications. Going back to the hypothetical, say you had a widget that improves engines, Why not include a claim to the most lucrative industry, like an airplane industry that uses engines that could possibly use your patent technology? Why don't you have that in mind in your specs so that when you go, once your patent is issued and you begin your patent licensing program, where you go assert and talk to someone, a representative from Boeing, to either license your innovative concept or to litigate. You want to keep all of this in mind when you're drafting your claim. So that would be the solution, is to add a claim, or at least have one set of claims that go towards where the money is. Follow the money. You possibly can gain tens of thousands of dollars of revenue from patent licensing royalties when you avoid this particular mistake. Okay, and finally, the seventh mistake that inventors make is a failure to present persuasive arguments in response to the examiner's rejection. You have to give, like that song says, give the people what they want. You've got to give the examiner what he needs to see. And if the examiner is saying this is not new, it's not novel, it is obvious, you've got to make a compelling, persuasive argument, present that before the examiner. And usually what you have to do is study case law. You might be able to Google, how do I respond to a 102 rejection? How do I respond to a 103 rejection? What we do cannot be replaced by Google. I think you need to really hire a seasoned patent attorney for that, or a patent agent, someone with 7 to 10 years of patent prosecution experience. You could try to make a go of it on your own if you are filing. Here's another way that you can get help. The patent USPTO does have an inventor support and helpline, and they will help you if you are drafting your case by yourself. But, be it known, you probably will not get the best protection, for your innovative concept, because they are not holding themselves out to be your attorney. So, if you can, it will be best to hire someone. You will save thousands of dollars lost due to filing and prosecuting your patent application. Okay, so those are the 7 mistakes. I am April Mosby, and I would love to work with you. I've worked with many engineers, business owners, entrepreneurs, just like you, and I would love to work with you. Signing off, please, if you like the video, give me a thumbs up and subscribe. I'll be giving you much more videos on a regular basis. You have a great day. Bye.